Well, it's actually really interesting because with the repudiation, overall, they when they got here, we were not deemed to be people and we were like animals, but they actually had to change it. I think it was about 50 years later, they actually changed pieces of it to say that we were human because there were so many of their Christian men having sex with our women that it was deemed to be bestiality because we were not human. So they were going to go to
Oh my
hell.
goodness.
Yes.
Oh my goodness.
Yeah, and to
Okay.
stop them from going to hell, then they
hmm
had to change. They had to change that, and then we became human.
Welcome to the Podcast for Inquiry, brought to you by the Centre for Inquiry Canada, a national educational charity supporting your community for reason, compassion, and secular humanist values. You have answers, we have questions. I'm your host, Leslie Rosenblood, board member and secular chair for CFIC. Welcome. On today's episode, I speak with Maureen Bulbrook and Christina Ninham. Maureen is a Haudenosaunee family law lawyer, Indigenous counsel for the Office of the Children's Lawyer, and a board director of Humanist Canada. Christina is a Turtle Clan from the Oneida Nations of Tams, a family law lawyer, panelist with the Office of the Children's Lawyer, and a Legal Aid Aboriginal Advisory Committee member. And Maureen and Christina have one more thing in common. They are sisters. Maureen and Christine talk about the Indian Act and its significance today, despite it being something of a misnomer. Christina describes the Doctrine of Discovery, how it shaped relations between First Nations and Europeans at the time of contact, and why its recent repudiation could have significant ramifications. One thing I learned over the course of the conversation is that discrimination against Indigenous peoples is not a thing of the past. The Canadian government passed a law in November 2024 banning forced sterilization because of the continued commonplace practice of doing so primarily to Indigenous women. There is much more that I learned, and I'm sure that you will too, in today's episode of Podcast for Inquiry with Maureen Bulbrook and Christine Ninham. Maureen Bulbrook and Christine Ninham, thank you for taking the time and speaking with me today on Podcast for Inquiry.
Thank you for inviting us here, Leslie, to have this discussion that we're going to have today.
I met the two of you at the Humanism in Action conference in Waterloo in November of November of 2024. It was and I really learned a lot from your talk, and that's why I invited you to come on to the show. And one of the things that you really opened my eyes to was how Indigenous nations within Canada today are still discriminated against, in not just on an individual level. Like I just have to accept that there's a wide range of types of people in Canada. Some of them are racist. Some of those are going to be prejudiced against Indigenous people. I don't like it, but I have to accept it. And of course, there are other people that are prejudiced against other minority groups. And I just have to accept that they exist. But what I learned from you was that there's a lot of institutional bias against Indigenous populations in Canada in terms of regulations, in terms of legal structures. And I was hoping that you could share with us how someone growing up Indigenous in Canada today faces how such a person might face obstacles or disadvantages that other people in Canada do not.
So there's a few ways of looking at that. I mean, I'm thinking that, like, if you look at it in a legalized way, one is starting with the whole issue of identity as an Indigenous person. And I think that there's a differentiation between Indian and Indigenous. And I think a lot of people think they're synonymous, but they're not. Like, Indian is a defined legal term under the Indian Act, and that is how basically everything starts on the I guess, raise this path that it goes down. Because you can be Indigenous and not be an Indian, and you can be an Indian and not be Indigenous, as long as you fall within the parameters of the sections of the Indian Act under Section 6. So I'm thinking that if we look at Indian as defined as a person who is registered or entitled to be registered under the Indian Act, then it would be totally different than someone who is not registered as an Indian under the Indian Act.
Right. And, I remember even as a kid, I was kind of confused by just the word Indian, because it has these two very distinct meanings, right? One is Indian as it's referred as you've been using it, which is a Canadian legal term to refer to registered people of First Nations. It also refers to the 1.5+ billion people from India, or that have Indian ancestry from that nation. And those two are very different concepts, but we use, I guess it's not an accident that we use the same word, because that's, I think, what we thought that when European settlers came to Canada, they thought they had found a path to India. So, of course, the people there were Indians, although it's completely on the opposite side of the globe. So what does registration under the Indian Act mean? Like, why is that a significant concept for an Indigenous person, and or a non-Indigenous person who's nonetheless registered under the Indian Act?
So, from my perspective, it's essentially allowing the Canadian government to define who we are as people. And it's also a way to assimilate and eventually try to eliminate Indigenous or Indians under the Indian Act, because it's all based on the resources that Indigenous people have here in Canada. I know my sister's going to expand on what I just said, so I'll pass it over to her.
So I think the difficulty is that the government gets to define who an Indian is. Whether or not they're Indigenous is a whole other story, because we have an adopted brother who is not Indigenous, but he is now an Indian under the Indian Act because he was adopted. So he gets to benefit from having a status card as being an Indian under the Indian Act with those privileges, but he doesn't have to bear the same scrutiny of actually being perceived as an Indigenous person in Canadian society. And I think the difficulty there is that it's so systemic and so institutionalized that, like, a lot of Indigenous people are viewed as being alcoholics or on welfare, and that we just live off the system, which is very frustrating because that is not accurate. But if you look at the way that the systems are viewed in court, like, there's a case that I know of where submissions were made that traditional Indigenous cuisine included hangover soup. And for judges not to call that out allows for I think an inference, that continuing inference that we are alcoholics and we are living in poverty and we don't have the same, I guess, ability to contribute to our societies.
So I also want to. Sorry, go ahead, Christina. I thought you were done.
No, go ahead.
Oh, I was going to say also the registration under the Indian Act too. So my children are also Anishinaabe, along with being Haudenosaunee. I'm Haudenosaunee. I'm registered to Six Nations, Upper Cayuga. Their father is from Whitefish River Reserve. And one of the things is that when our kids were young and eligible and for status, we had to determine which band that we were going to register our children to, because you can only be registered under one band under the Indian Act. So initially, I did register my children with Six Nations, and then as they got older, we actually transferred my girls to their dad's reserve, because they do have land on the reserve, family land, whereas I don't have any. on Six Nations, so it made sense that I'd register them or transfer their registration to Birch Island. And the other thing is that when I did transfer them, there actually has to be a community notice to see if the community would actually accept my girls. This goes for anybody that transfers to accept them as members of the nation. And then there has to be a band council resolution in order to accept them onto the registry. So it was a bit of a process, but they were transferred to their father's reserve. And we did have to pick one or the other.
That's interesting because Canada recognizes dual citizenship. Like if someone has for example, Canadian mother and American father, you can be both. The child can be both a Canadian citizen and a U.S. citizen. That applies to many other countries as well. But Canada doesn't recognize or doesn't have the concept of, like, I don't know, dual citizenship or something equivalent when like one parent is Anishinaabe and the other is Six Nations.
And that's on purpose. Like, I think that's on purpose because systemically they still want us to be Canadian. I don't consider myself Canadian. I am Oneida. I'm Haudenosaunee. I'm Turtle Clan. So I was adopted into the Turtle Clan through the Haudenosaunee Great Law, which is totally pre-existing Canada and Canada's implementation of their own laws. So, but I am registered to Six Nations as an Upper Cayuga. I consider myself Oneida. And I think the difference there is that systemically the government still wants to have us assimilated into Canadian society without accepting and acknowledging our pre-existing rights and our pre-existing abilities and our governing structures and our education. Like, we had all these systems prior to contact, but because of the Doctrine of Discovery stating that we were not human, they were not accepted and recognized, except to the point that they needed to use us to fight their battles with whatever other people came from across the ocean. One of the difficulties too that is really obviously prejudicial is that, like, my sister and I have 4 brothers, and so my daughter is registered to Oneida because my husband was a 6-1, but all our 4 brothers, none of their children have status, even though they are our brothers. So their children they're not entitled to status under the Indian Act right now as it stands the way it is.
Okay. So we've talked a lot about status under the Indian Act, but what might not be clear to our listeners is, why is that relevant? What is the significance of being recognized or of being categorized as a particular nation within a particular nation under the Indian Act? Or I guess more simply, what's the difference between being a status and non-status Indian? Why is it relevant, Christina, that you have status and your children have status, but that your nieces and nephews do not?
Well, there's a whole other subsect that we can look at that with that particular question. So if you look at the way society is ran, primarily you have to look at the Constitution of Canada, and that defines the division of powers between the province and the federal government. So under 9124 of the British North American Act, so the Constitution, Indians and lands reserved for Indians are deemed to be under the responsibility of the federal government. So the federal government implemented the Indian Act, which defines who an Indian is, and therefore they are basically responsible for Indians. And so when you're dealing with the issue of Indians and not, like, the not status is a bit different because there's some limited ability, but under the Indian Act, if you live on the reserve, we are governed every single day under the Indian Act. And the basis of the Indian Act is really to still try and get rid of us. And the difficulty, and I can tell you that my firsthand experience, because I've been at Oneida now for 25 years, my firsthand experience is when my husband died. And the difficulty, because there's a state provisions in the Indian Act and under Section 88, laws of general applicability of the province would apply. But because the estate issues are under the Indian Act, trying to deal with my husband's estate was very difficult. And even just trying to transfer our vehicles into my name after he passed took almost a year, because every single time I went in there, it was so obvious that they did not understand the difference, and they did not want to understand the difference in having to deal with the estate issues when you're dealing with an Indian on reserve. So it's things like that that most people don't think anything of or don't know about. And then when we have to go and deal with those issues, it's so frustrating. And then, like, I even got in an argument with one of the lawyers when I was dealing with one of the banking issues. And I'm like, you don't know what you're talking about because you're dealing with this with your provincial eye. And so basically, like, you almost have to call them out to say, hey, what you're doing is wrong, because your race government is basically dictating what policies and procedures are supposed to be followed with respect to me as an Indian under the Indian Act dealing with the estate of my husband who is an Indian under the Indian Act. So, like,
And there are,
and they make
I mean, you're a lawyer, so like you're among the best placed to deal with these issues. If you're having trouble, I can only imagine what it would be like for others who are not as knowledgeable and not as connected as you are within the legal system. But uh, implicit on what you just said is something that I think many people will find surprising, and that, like, is there a different set of laws that apply to status Indians versus the set of laws that apply to, I guess, everybody else in Canada? Because I think that's what I heard you imply, although you didn't
yes.
state that. So I want to bring that to the surface and say, is that an accurate statement? Are there a different set of laws? Is it a different set of just procedures, of regulations? Like, why is it different for you as an Indian under the Indian Act than it would be if you were the same person but not a status Indian under the Indian Act?
It is a different set of laws, a totally, completely different set of laws. And right now, it's actually almost frustrating because we have the Indian Act that defines us, but it also enshrines the basis of the relationship of all the things that we actually have as benefits as Indians under the Indian Act that came to negotiations and treaties as nation to nation relationships. So the difficulty that we have is that if they repeal the Indian Act was premised on basically trying to assimilate Indigenous people to get rid of us and make us part of the fabric of Canadian society. And we still don't want that because we still want to be able to maintain our structures and our the way that we live and our way of life and the way that we view the world. And so, like, one of the difficulties is as Indigenous people, we're born into roles and responsibilities. Non-Indigenous people are born into rights and privileges. So when we look at the world, then we are responsible for the past, the present, and the future. And we are here to try and make sure that we can provide for each to make sure it benefits everyone as a whole. So when you look at non-Indigenous people, it's very civil, like rights based, and that's the way that the laws are premised. So they want us to conform to the way that they look at the world, which is totally contrary to how we look at the world. And so the difficulty there is that they've enshrined what they want to happen in the Indian Act and have tried to disregard the actual nation to nation relationships, like, for example, through the two wampum. So to make a long story short, because I know we don't have that much time and I could speak forever, but to make if you look at the way the government still is now, the federal government has the Indian Act, but there's also an act with respect to children, youth, and families. I'm saying it wrong. It's this whole super long act with respect to children, youth, and families. Um, no, child, youth. I do this every day, but I just call it the Federal Act.
It's an act respecting First Nations, Inuit, Métis children, youth, and families. That's the long
So
name,
that
and we just
that
need the
right,
federal.
and that is federal legislation, but that it also almost contradicts the Child, Youth, and Family Services Act. But the federal act is actually paramount to the provincial act. So to try and get an understanding of who is defined as Indigenous, because it's a different test, and it's not even Indigenous, they say First Nations in the acts. But you don't have to be an Indian under the Indian Act to qualify for the federal act and for the provincial act. So it's a very complicated, frustrating thing for non-Indigenous people and even a lot of Indigenous people to understand, because the really it's almost like a divide and conquer technique still. So they want to be able to create this divisiveness, and then it's propagated through the use of their legislation. And if you look statistically, Indigenous people are overrepresented in every single major system, like child welfare, suicide, like health issues, incarceration. There's I think for over 40% of the kids in care in Canada are Indigenous, but the population is equivalent to I think about 4%. That's the last time I understood it, but like the statistics are gigantic, and no one's doing anything except creating different legislations that make it harder for us to deal with our own stuff.
And one of the things when, in my work, I always tried to push and say, we shouldn't rely on case law when we're applying the federal act. It should be on a case by case basis, because how do you undo the wrongs when you're relying on cases that were essentially bringing kids in care, but that's what continues to happen. And then, sorry, going back to the question between the status and non-status, there
Mhm.
are some parents who are eligible for status or have their status that don't register their children under the Indian Act because they don't want um, to be governed or have that definition of the Canadianized name for them as an Indian under the Indian Act. But then we also see the issues where it's almost like my sister said, like the divide and conquer thing, because when we look at when there's treaty negotiations and there's settlements that come out of it, that essentially if you're not registered with the nation that is negotiating or has the settlement that has come out, that basically a non-status person that would be eligible for registration would not be entitled to the negotiation settlements that are engaged in. So um, I don't want to call that a benefit, and I don't think that anything under the Indian Act is a benefit. I think it's the reason why I registered my children was first, my parents registered me. So I just thought it was the normal course to register my children. And as I, started, educating myself more on my own background, uh, because I did grow up in an urban area where there wasn't a lot of Indigenous people, and so learning about myself, when I think about it, I'm like, I did the process of registering my children, but not thinking that it's the government that's defining. But now I look at it as I would have registered my children anyway, because I think it's, this may sound funny, but it's one way to actually have the government actually flow funds to, Indians that are registered under the Indian Act. Otherwise, there would be some lack of care for the ones that are non status. So we do have a very minimal dental under the Indian Act, minimal prescriptions. There are what people would call benefits, but I think it's something that's based off oppression, and that it's one way that being registered that the government will pay for. somewhat towards us for the wrongdoing.
So the Indian Act sounds like it's a bureaucratic nightmare on a number of levels. Like, first of all, there's the definition of who and who is not entitled to be an Indian, whether that classification applies at the provincial level. There's a different set of definitions that go on to different laws apply a different standard. You get bureaucrats who are not accustomed to dealing with Indigenous concerns, or are not aware that there are a separate set of rules, so we're trying to apply the other set of rules. But there's also perhaps a general sense that there should be one law that applies to everybody. Like, everybody in Canada is subject to one law, and that you don't carve out exemptions for special groups. And so I've heard for a number of reasons that some people want to repeal the Indian Act, and there are people that are very much in favor of that, and others that are opposed. And I was wondering what your thoughts were on whether the Indian Act should continue to exist in Canada, or whether it should be amended, stay as it is, or taken out in its entirety.
I think that's a really difficult question, because I think the Indian Act is actually what holds the government accountable to our nation-to-nation relationships. And I think as Indigenous people, pre-existing contact and having our governing structures all across Turtle Island, I think the difficulty there is we are not Canadian, and we should not have to be forced to be Canadian to be able to maintain the lifestyles that we have had and our families have had since time immemorial. And like, realistically, if you look at Canada, even with urban sprawl, it totally still infringes on our rights, our treaty rights. And if you look at Haudenosaunee people, their Nanpan Treaty covers land, like, basically going from Ohio, New York, Ontario, into Quebec. And it's a very wide swath of land. So, like, it's the Beaver Hunting Ground Treaty is what that treaty is in particular. And if you look at the way that it's premised, we have to endure the fact that the Canadian American governments, or the British at the time, and the US decided to unilaterally put this weird border across our land, just randomly, however they wanted to. So our people are subject to these laws that we should not be subject to, because we are not Canadian and we are not American. Being North American, we should have the ability to cross without issue. And the Jay Treaty actually says that we're supposed to be able to have the right to cross without issue. But that doesn't mean that it's going to be enforced, because it's going to be totally subjective when you get to the border and deal with the prison guard, the customs border agent that you're dealing with. But it's funny, because they actually did use, they have used the border people, like, to make sure that we either can't come in or stay here. So they use those, even though our traditional lands exceed the border, we are bound by the oppression of what they think we should be complying
with. And I think if the Indian Act was repealed, I think there's be some nations that would struggle more than others, unfortunately. And I think it would be placing them in a very difficult position, because there are certainly some First Nations that are really thriving with their economic development, so that they could try to be self-sustaining if they need it to be. We have to remember that there's no tax base on a reserve, right? So when you live on reserve, it's you do have a tax exemption. I do want to mention, though, when it comes down to child support issues, if there's provisions in the Family Law Act that about the child support, the Children's Law Reform Act, and basically, if you have tax exempt income, that your income can then be imputed to a higher amount. to gear it so that it's like you're paying tax. And so I look at that and go, who does that apply to? Mostly it's status Indians on the reserve. So they're having their income imputed higher for child support when you're making uh, tax exempt income on reserve. So so there are, like you said earlier, different rules that do apply to Indigenous people, and that's just one example.
And that's not one uh, to the benefit of Indigenous people. That's one that works against them.
Yes, of course, for the payor, for sure. For
Hmm.
the children, maybe not, and that's why they're dealing like focused
Hmm.
on that. But overall, yes. And then there's other issues like where the Huron Robinson Treaty. There was a settlement that came out of there, and many nations that fall under that treaty, where we have the Family Responsibility Office, that are now pursuing to obtain child support from these people that are getting their settlement money, and it's like, at that point, how do you sit there and take basically like oppressive negotiated money, and then apply it to child support? And I understand the reasons, yeah, people should pay for their children, but at the same time, would I classify that as an income? I wouldn't. Like, it stems from the oppression of what happened, and out of that, and then to sit there and try to garnish that settlement money from a payor. I think I struggle with that too, because there's reason, and that's what even happened with the residential school money too. So it's one of those hard issues, because they have an obligation to pay, but should that money be included or garnished for the purpose of the support? And I know that sounds like a silly issue, but I mean, it's an example of how things are impacted, and how circular, and how systematically ingrained, the racism issue is for Indigenous people. And I do want to say this, Leslie, too, that the Indian Act only applies to people that are eligible for, like, under the Indian Act. So it doesn't apply to Inuit or Métis people at all. So they wouldn't be Indians under the Indian Act. And I just thought I should mention that.
I just wanted to
Okay.
touch base too with respect to the Indian Act and the premise of the Indian Act and the previous Gradual and Civilization Act and the Gradual Enfranchisement Act. They were the premises of usurping the traditional government of nations across Canada. So with the implementation of the Indian Act, a lot of the nations actually no longer have their traditional governing structures. And the difficulty, if like band councils obtain their authority through the Indian Act. And if you repeal the Indian Act, all those nations that now use a band council to function as a traditional, that would be the traditional government that would have to basically be implemented with any type of repealing of the legislation. Like Haudenosaunee people, we have a traditional governing structure that exceeds Canada and the United, like it's North American. We still have a government. We have passports. We have identity cards. And as Haudenosaunee people, we can still travel to other countries around the world, just not the colonial countries, because they don't want to accept our governing forms of ID. So I think a lot of it has really to do with how the state is of particular nations across Canada, because some of them actually do feel like they're Canadian. And if they are Canadian, then I think that's where everything is being looked at in a municipalization view as opposed to a nation to nation view. And that's where there's a slippery slope, because not every nation in Canada considers themselves Canadian and don't want to be Canadian because of the oppressive, assimilative, and genocidal policies of the Canadian government.
So, as appealing as they are, unfortunately, I think this is another example of how simple solutions to complex problems simply don't work, and would not be effective. Uh, let me. I think there are like two major things that have happened in the last 15 years or so that non-Indigenous people will remember about Indigenous relations. And one was the apology made for residential schools by Prime Minister Harper in 2008. And this was, if one believes what the government says and the media reported, going to be a new chapter in Canada Indigenous relations, turning over a new leaf. We'll be able to start afresh. And then when Prime Minister Justin Trudeau was first elected in 2015, there were basically two things that came out immediately after his election. And one was that it was the first time in Canadian history that the cabinet had an equal number of men and women in it. And there was a promise made at that time to give all Indigenous communities access to clean drinking water. And so we're now 9 years after that statement, a bit more than 9 years now. We're in December as we're recording this, December this in 2024. What's your reaction with the ability of some hindsight to Prime Minister Harper's apology and the dawn of a new era of Canada Indigenous relations, and to the federal government's promise shortly after the election of Trudeau the first time to give clean drinking water to all Indigenous communities across the nation?
Those are two, for me, politically contentious issues, because Harper, I think, was trying to pay lip service to Indigenous issues. But so on his right hand, he's saying, giving this apology. On the left hand, they were looking at destroying all the records dealing with residential schools. So they actually were trying to, if you look at what happened with Germany and with the war with Jewish people, they actually have museums and they have things in Germany to basically say, let's not relive this again. Let's acknowledge that this happened. Let's put up museums. Let's do this. In Canada, it's almost like, let's ignore it. Let's get rid of all the records. Let's ignore that Indigenous people still exist. Let's assume we're going to keep on going with our assimilation policy. And let's see if we can basically deal with the Indian problem once and for all by pretending that it doesn't even, it's not there. And so that was really frustrating from my perspective. With respect to Trudeau, I drink bottled water that the nation provides because they have such an old system. And there's so many reasons that they want to blame us. Okay, so basically in 2008, I actually found it frustrating because it doesn't mean anything. Apologies don't mean anything when you don't mean it. And at the same time, on the right hand, he's giving this apology for residential schools on behalf of Canada. On the left hand, he's totally saying in the background that we should be destroying all the records and everything that relates to residential school to basically eliminate it as an issue in Canada. I think if you look at Germany, for example, what happened with the war, they literally make sure that everyone knows about the issues that happened and with the war, and they have museums and they have different things in their education system that make everyone aware so that the problem doesn't happen again. But here, it's almost like they want to hide this dirty secret and they just want to get rid of it and destroy it, and they still just want us to be enmeshed in the folds of Canadian society. With respect to Trudeau, the difficulty there is that water is a fundamental basic human right. And I think in November, the government at that time was basically saying that, Indigenous people really aren't worthy of this basic human right of clean drinking water. And of course, that's not how the submissions were made, but that's basically what you can infer the submissions in these cases are basically saying. And Canada continues to have water issues. Oneida, we end up picking water up from the community center because of our water issues and the infrastructure being so old and the inability of the guaranteeing of clean drinking water. So we are about 20 minutes away from London, and London is not that far away. And it's funny because the day we went on a boil water, in the paper, there was a water park that opened up in Strathroy, which is 20 minutes the other way. So, there's a lot of discrepancies in there, and the acceptability for these fundamental basic human rights not to be fulfilled for Indigenous people because systemically we're still viewed in an inferior way.
So I have perhaps some sympathy for the government if there's a fly-in community in the middle of nowhere, not close to basically anything else, and how to guarantee safe drinking water to that community if it's not already available. I can understand the logistical challenges associated with that, and I'm trying to give them the benefit of the doubt. But the example that you just used, Christina, this is a community that you said was 20 kilometers outside of London. It would seem to me that it would not be a logistical nightmare to essentially install a pipe, like an extension of the existing London water infrastructure to include that community. And is why hasn't the Canadian government, or I don't know, maybe it's the provincial government, is it the municipal government, but why hasn't Canada writ large been able to supply clean drinking water to a community that is next door to a mid-sized Ontario city?
That's a great question.
Do you have any insights as to why that might be? Because it's from my perspective, that's a complete that seems quite mysterious, or puzzling. I can't think of why that should be the case. If it is, do you have any insights that would be comprehensible to me and others?
Okay, so the way I look at it, and I'm pretty hardcore with my indigeneity, is that water systemically is required. And I think that they use the issue of water to basically try to control us still in order to, because they still want us to be Canadian, they still want our resources, they still want our lands. And realistically, they don't own our land. The Pope repudiated the Doctrine of Discovery last year. The Canadian government relies on the Doctrine of Discovery, saying that we weren't human, to justify their ability to maintain Canada in a fee simple type ownership with the Crown having underlying title. So if you have our nation saying that, no, you don't have the jurisdiction and justification to do this to our land, because systemically it's all about oppression and ultimately capitalism, corporate greed, everything, the way the whole system is. But our systems were not like that prior to contact. Our systems were very communal, and we all lived in longhouses, so we didn't have homelessness or hunger the way that they have it now. If there was hunger, the hunger would be across our whole village. And our villages, some of them were tens of thousands of people. They found longhouses that were hugely gigantic that could sustain 10,000 people. And I think that's where the difficulty comes in, because it's a complete disregarding of who we are as people, because systemically we are deemed to not be people under the Doctrine of Discovery. So if they actually acknowledge and accept our humanness, then I think that puts it on a whole other different level, because then they can't just treat us the way that they treat us. And they get to justify the way that they treat us because of that.
So your position is that the reason that this community outside, Indigenous community outside London, doesn't have clean drinking water is that essentially it's negotiating leverage, uh, and, uh, and a desire to extract more from the people that live there. Is that a fair summary?
Yes, because I think that if you look at the way that our land base is premised, well, Oneida is different because it's a settlement. So it was actually bought and it was paid for. So even though it's on our traditional lands, which we can also, like, I could totally go on a whole tangent about land issues and the differences and how Indigenous people look at overlapping land rights. But fundamentally, we are in what is the Beaver Hunting Grounds Treaty. So we are here, and systemically, Canada wants to make sure that they know that we are Oneida Reserve number 41. However, as Oneida people, this is our land that we've held since time immemorial with other nations because of the overlapping land rights. So Canada likes to basically say, oh, here, let's say, for example, Toronto, and like Toronto Island, they dealt with the Mississaugas of the Credit. But like if you look at the way that overlapping land rights occur, it wasn't just Mississauga's land. They shared it with Anishinaabe, they shared it with the Haudenosaunee. Everyone used the land at different points at different times. So like they think, okay, but now we've just treated with the Mississaugas of the Credit, so now it's dealt with. But it's like, oh, that's not the way it works, but that's the way it works in Canadian common law, so that they get to narrow the issue. So like it's frustrating because if you look at the way that we look at the world, then everyone was open and welcome. And like one of my favorite things about being Haudenosaunee is that a fundamental basis of the way that we look at the world is everything has a right to exist. And when contact happened, despite the fact that our I guess our civilizations were very different, we looked at them and said, okay, that's interesting. You guys look at everything in this interesting way because they have like a whole kingdom and or queendom of however they want to deal with their governing structure and their subjugation. But we had a different communal view. And so when they came in to take that, they literally used, I think that they used the issue of water as a control issue, because if you look at how everything is, they have the ability to fix the water issue, but they choose not to. They can put the funding in. They are literally billions of dollars in debt, so it's another 10 billion to fundamentally put the water in instead of sending the money out of Canada into other different things that, like, I don't know why, whatever issue, political issue is of the day. So my premise, the way I live my life is I am on my soapbox for Indigenous people, for Indigenous issues, because systemically we are constantly dealing with a battle against colonial oppression, and we not only that is we are subject to what the colonial courts assert upon us. And there's no way as Indigenous people we have the ability to fight colonial courts to assert our jurisdiction and our right to exist in a free state how we did prior to, because they continue to maintain that they have control over us through the Indian Act and through the Doctrine of Discovery, which has been repudiated, which says we're not human. But like
Right. So
fundamentally,
you've mentioned the doctrine of discovery a few times now, and I only learned about it about a dozen years ago myself. I was shocked when I did. But in case that there are our listeners who are unfamiliar with the doctrine of discovery, can you tell us what it is and why the repudiation matters and where that leaves us today?
okay, so when contact happened, the Doctrine of Discovery pre-existed that you are not human unless you're Christian. So at contact, we were not Christian. And
This was a dictate from the Pope at the time, from hundreds of years ago, that the
yes,
only people that were human were Christian. Okay.
yes. So we were
I
deemed
wish
to
I
be.
could say I'm shocked to hear that this was the perspective of the Christian Church, but I cannot honestly say that is that's less surprising than it should be.
Mhm. Well, it's actually really interesting because with the repudiation, overall, they when they got here, we were not deemed to be people and we were like animals, but they actually had to change it. I think it was about 50 years later they actually changed pieces of it to say that we were human because there were so many of their Christian men having sex with our women that it was deemed to be bestiality because we were not human. So they were going to go to
Oh my
hell.
goodness!
Yes.
Oh my
So they,
goodness!
yeah, and to
Okay.
stop them from going to hell, then they
Mm-hmm.
had to change. They had to change that, and then we became human. And in some books written by not our people, but like colonizer people, they like we were looked at animals. So like even in some parts of North America, they would eat us. So like it was like really kind of gross, and so we did not want to like partake in that part. But um, with the assertion of the doctrine of discovery, they use that as a premise to set the basis of maintaining ownership of the land at contact. So right from the beginning of contact, the land was terra nullius, so it was deemed to be vacant land. And then they got to control as much as they could using our people as like soldiers in this what became like a war in the whole fur trade and everything else. So the royal proclamation, when that was asserted by the king, he ended up saying that the land is there. So basically, that's when underlying title to the crown happened was with the royal proclamation, and that's
Okay,
when.
so was the Doctrine of Discovery a religious edict from the Pope, or was it a royal proclamation from the King? I just want to make sure that I get this correct.
It was from the church, and that's how it started because it pre-existed contact.
Mm-hmm.
However, by the time we hit the 1700s, and I think it
Mm-hmm.
was 1763. That's when the That's when the wars were coming to an end because they were like the British had won what they were trying to get. So they treated with the other people that they were at war with, but they did not include Indigenous nations in their treaties. So a lot of Indigenous people were slaughtered by the same governments that they had just entered into a treaty with. So um, the doctrine of discovery is still used in case law. I haven't seen it used since it's been repudiated, but I have seen it. I think it's as recent as 2012, and it's even in the Dalvin decision in the I think 96. So if you look at the doctrine of discovery and the fact that they use that to assert their authority over our resources, it's actually still kind of sickening. And now that the Pope has repudiated the doctrine of discovery, to me, I think everything should now be opened up saying, hey, you know what, we've been human all along. Maybe we need to share resources as opposed to basically you just taking everything.
Well,
So,
we were talking about the Indian Act earlier and how repealing it would cause this kind of chaos of because so much of that, among many other things, I think the example that Maureen gave was that many band councils derive their authority from the Indian Act. So if it were just repealed, then they wouldn't, where would they derive their authority from? But if so much of what currently constitutes North America, Canada, United States, and Mexico, is based on the doctrine of discovery, where the beings that were already here were subhuman, being non-Christian folks. Uh, then, if that's repudiated, doesn't that call into question the foundational uh, the foundation in law on which these three nation states are based? I'm not a
Yes.
lawyer. I'm going to defer to your expertise on this, but it seems to me that if that was the foundation of why we could just why Europeans could just come in and say, oh, there's nobody actually here, and we have discovered this land that nobody else has been here before. We plant a flag, it's ours, expands out, it now covers the entire continent. If the very foundation on which those assumptions were made and on which these three nation states are are, are based on is now deemed to be null and void, what does that say about the validity of these three nation states?
For me, there's a legal term called the status quo, and I think people
Mm-hmm.
even use that in everyday terms. So I think that would be one of the justifications is that it's the status quo now. It's been assumed for a very long time that the crown has the underlying title of the lands and even the lands reserved for Indians. So they there would be some form of legal justification if that argument ever arose, and I think that like the status quo argument would be one of them. Um,
Okay, I mean, I'm not calling for the dissolution of the Canadian state. I'm trying to explore the ideas here, but because I don't know what that would look like, and I'm not sure that would be a good thing. But it does seem to be a logical ramification of the repudiation of the doctrine of discovery.
I agree. And I think that that's where the difficulty is because we're never going to win in a colonial court. So how can we fight Canada in a Canadian court? They will always continue to side for Canada. And you can look at the way that even child protection and Indigenous issues are. When you're sitting there having a trial with an Indigenous child and you're trying to advocate for the child to be returned home because of the federal legislation, and then you have a judge who doesn't even know what Jordan's principle is. It's astounding that that judge gets to sit and deal with Indigenous people because
Okay,
of the
Christina,
ignorance.
you're going to have to explain for our listeners what is Jordan's principle.
So I think it was about 20 years ago now. So it's been 20 years that the First Nations Caring Society brought an application to the Canada Human Rights Tribunal to assert that Canada is discriminating against Indigenous children because of the chronic underfunding with respect to child protection. So they actually won, and they've continued to win for the last 20 years, despite the fact that the Canadian government continues to spend millions of dollars fighting against equality for Indigenous children. And so what's happened is one of the decisions that resulted from the Human Rights Tribunal was that Canada's chronic underfunding, they had to establish what was called Jordan's principle because there's actually a child that was named Jordan, and he was from Norway House up in Manitoba, and he had significant health issues. He had to go down, I think it was to Winnipeg, and what happened is instead of sending him home because he was critically ill and he was probably going like he was going to pass away. So he was never home. He never got sent home because the Ontario government and the federal government fought about who was going to pay for the resources to ensure that his health needs were met while he got to go home. So basically from there, they now have Jordan's principle to try and address the fundamental inequality for Indigenous children to for it to be the government of first contact that is to supply the requirement of the child for whatever that need is for that child. And then the governments themselves have to fight out later who's going to pay for what after it's already been paid for. So it's basically Jordan's principle is about trying to address the inequality of the lack of resources supplied for Indigenous children. And you got to remember, Indigenous children were always considered like that. That's a point of first contact because when you attack the language and you attack the children, then you're basically attacking the whole premise of that nation. Because if you have the children lose their language, it's the language that provides what your worldview is going to be. So they wanted to attack our children, attack our language to stop what our worldview was to become Canadian. So the chronic underfunding is like systemic because they did not view us as human. And they actually used Indigenous children in residential schools to come up with Canada's food guide by eliminating certain nutrients or whatever in the diets to have deficiencies to see what happens when you
Oh,
give kids. Yes, it's disgusting. And it's actually, it happened. And the government it was actually the physician general that was the one that thought it was a great idea to have. So when you look at the way that Canada continues to treat Indigenous children in this way, they create the federal legislation. They create this way where the government, like the judges have a hard time thinking outside the provincial box. But systemically, the judges that deal with these issues with Indigenous children, when you have a city that has a reserve, like 3 reserves actually, like let's say London has 3 reserves outside, like there's a huge number of Indigenous people in the courts for child protection and criminal matters because there's always this chronic way that our systems don't blend with theirs and they keep trying to make us something that we're not. So when they push and push and push, it just increases the statistics because we're never going to work into their system the way that they want us to blend. So I think the difficulty is we can't be the same as Canadians because we're not Canadian. We have different systems. We have different ways of like looking at the world. And I think that's where the
you repeated a claim a couple of times in there, and I want to get more specific on that just to make sure I understand. You mentioned that Indigenous child protection services are chronically underfunded. Now, let's take the City of London. There are people who have children that are very bad parents in the City of London. Uh, and so we have child protective services to look after the best interests of the children. I'm going to assume that there are people with children on Indigenous reserves outside of London who, for one reason or another, are not very good parents, and therefore there are protective child protection services targeted, where those services are targeted to Indigenous for the Indigenous children there. Now, I hear it's a common complaint that probably if I were to speak to a child protective worker in the City of London, he or she would also probably complain that their office is underfunded. I hear that a lot from people that work in such things. Is what you're saying similar to what my imaginary London City of London based protection worker would be saying, or are Indigenous child protection workers underfunded in a different way than is generally the case? Is there a difference between? I guess the key question is there a difference between an Indigenous child protection office and just a city child protection office?
I have to say no. I think that they pretend that there is, but everything has to comply within the legislation under the CUFSA. So you can have a Brown agency, but it's still a child protection agency that has to comply with the policies and the laws of the provincial government. So until you change those, until you change the criteria, like until you have it where, like having a wood stove in your home is a risk. That's a child protection risk. So when you look at the issues of the funding, it's not just the funding to sit there and run this system, this colonial based system that does not benefit Indigenous people at all. It's about addressing the systemic nature of the government's chronic oppression and assimilation and genocidal view to get rid of us, and then coming to a point saying, hey, well, maybe we still want to be Canadian, but we don't want to kill you anymore, but we just want to try and get you to become more firm in Canadian values. So the difficulty there is like there's still some of us. I don't celebrate Canada. I don't celebrate genocide or assimilation or oppression. And for me, the difficulty is when you're dealing with Canada, like they have this great world view. Well, I don't know lately, but anyways, they like overall Canada has always been seen to be equal, but it's like this hidden thing in the back where we just get put to the side and we don't get to explore who we are because the oppression has been so bad and they literally took our children and then they expect our children who grew up in residential schools to be the perfect parents and then they can't be the perfect parents because they've never been parented in the way that our systems actually had them as parents. So then they come like it's really a generational issue. So if they put the same amount of money back into helping us with our communities to rebuild them in ways that benefit our communities, that's where the difference is. And that's where I have no sympathy with respect to resources. And we only have to look at the Huron Robinson Treaty to see that like I I think a lot of Canadians don't actually know that they're treaty people and that there's so many treaties across the government. Like my sister and I get $2.50 a year through being Upper Cayuga registered to Six Nations as Upper Cayuga people. So they
two
don't
dollars
actually
and 50 cents a year. Oh, so
yeah.
you don't even have to work as lawyers anymore. I mean, your needs are covered.
Uh, but they don't even let us collect it every year because it costs too much to administer. So we can only collect it every 2 years. So we get $5 every 2 years. So the interest on that, woohoo, like. But it is a systemic issue because the chronic, like I guess, ignorance or the fact that they don't educate Canadians in these systems, in who they are as treaty people, in the relationships, because for them it's like a past thing. This is the history. This is past. But we live this every single day. Like we are living this every single day, and for us, it is not a historical issue. Like this is a chronic issue we live, and that is probably the most frustrating part because like we go and we deal with people and it's funny because I I'm dating a white guy right now and this is the first white guy I ever dated and it's funny because he now notices the conversations that he has but when I'm not there clearly about how racist like the people are randomly when he goes out and it's like they just think that we're all on welfare and we just get everything and we're totally tax free and we get the benefit from everything in the world. And I'm like thinking, wow. But it's like this chronic ignorance. And it's frustrating because I'm 51 years old and I tried to educate for such a long time and I'm tired now. Like I don't want to stand on my soapbox anymore because it's just exhausting and I'm handing my baton to the next generation.
Sorry, I want to add to what Christina said about so most agencies are funded all the same and under the ministry here in Ontario. Um, and one thing about Ontario child protection agencies, they're all basically individually run, so they're more quasi government, you know, funded through the government, but each run individually. But they all are supposed to apply the same standards. And as Christina mentioned, you know, when you're applying uh, like the Canadianized standards to Indigenous people that are overrepresented or overrepresented in like poverty, lack of housing, incarcerations, and child welfare. Uh, like there has to be some form of a different process to try and keep these kids at home. And for me, when the federal act came in, an act respecting First Nation, Inuit, Métis children, youth, and families, came in January 2020, and I was at a child protection agency during that year, I really, really tried to say we have this piece of legislation that we could use to deviate from the standards to try and maintain children in the community, try to maintain them in their home, or try to maintain them with families. But it's really hard to get people to start thinking, differently on how do we sit there and address the what some perceived as concerns, say for a wood stove being in the house, or having basically an open concept kind of home where you have maybe two bedrooms and you have like 8 kids, right? So some people are thinking, oh my god, how do you have like that many kids and only that many rooms? It's like, but as Haudenosaunee people, we all lived under the same roof, like in one long house, right? So when you
Mm-hmm.
think about the concepts of even having bedrooms and privacy, I get that, people think it's necessary, but ultimately it's not. Like, to maintain and keep families together, it's a materialistic idea and goes to like the greed and wanting what everybody else wants. So if those standards can stop, like, be changed in some way when it comes to impacting on Indigenous children, like it's supposed to, the way the federal act was supposed to work to try and minimize the number of children in care, which it hasn't, because although Christina said it was 40%, it's actually 53% of the children across Canada are Indigenous. So even with the federal legislation being a Canadian wide minimal standard legislation, it still hasn't reduced the number of children in care. And it's quite sad. And I think, it's because they're Indigenous people are having like the standards that apply um, uh, as every other Canadian in some way, instead of gearing it to, the situations that are happening, because we do have, basically third world conditions in Canada. We have reserves that have no clean running water, that communities are actually removed because of flooding issues every year, or forest fires, or chronic lack of medical care, high suicide rates, the cost of food, even, right? So, like, there's like all these different conditions that do apply to different Indigenous communities across Canada.
We've touched on several issues, each one of which could be, I think, its own episode, and there's many more that we haven't. But I think we've talked about enough things that if people are curious to learn more, can you provide some suggestions of how people can learn more about uh, Canada Indigenous relations and the current state of where things are?
So for my thing, like, the news is pretty geared to not report a lot of things on Indigenous
So,
issues.
so where can people find out good information, accurate information?
So I get some of my information, and I know this is going to sound a bit ironic, but the Canadian government websites do actually, have a lot of information about different things on there. You can look up First Nations communities and see what's happening in their communities about what's going on. Uh, there's looking up even just Indigenous news, and then we have the APTN uh, channel, that is the news channel, Aboriginal news channel. So there's lots of resources that's out there.
And not only that is, if you look at the recommendations of the TRC, those are recommendations that aren't just for the Canadian government. That's like a recommendation basically to help educate people in understanding the issues affecting, sorry, helping Canadian people understand the issues affecting Indigenous people. And you got to remember there's the Royal Commission on Aboriginal People, which would have been from '96, and then you have the TRC like 20 years later, and then you have the Missing and Murdered Indigenous Women and Girls report, and then I think there's another like a residential school report, and there's a like if you can find it if you actually want to look for it because
Right. And
it's so obvious.
I'll provide links to the Truth and Reconciliation Committee's reports and their recommendations. I'll also include a link to the murdered and missing Indigenous women findings. I'll put a link to that in the show notes. So if people want to learn more, uh, those are places to start.
Okay, and I just want to add a little asterisk there. So the
Mm-hmm.
TRC is like some of the stuff that we see, like I see as an Indigenous person, is
Mm-hmm.
like the TRC, for example, was originally Justice Harry Laforme was on that prior to the Justice Sinclair. So just as the form got off it because he was not able to do what he wanted to do in that report. And that's the part that I find frustrating because Justice Sinclair did the report, but he also, in my perspective, the way I look at it is he minimized what he needed to do to create a balance for it to be acceptable to Canadian people as opposed to coming out in what was actually said. Like, for example, the government didn't engage in cultural genocide, the government engaged in genocide. So putting the word cultural there minimizes the actual impact, but it makes it easier to swallow for Canadians. And I think he did that in a way to try and make it so that it didn't seem as bad as it actually is. And that's one of the things that I find frustrating about those pieces with respect to the reports. It's like when people look at the AFN and they look, oh, well, the AFN represents Indigenous people across Canada. Well, no, it doesn't. It represents band councils in Canada. So the AFN is funded by the Canadian government, and the
And that's the
AFN.
Assembly of First Nations, in case someone doesn't know what AFN stands for.
Sorry, I apologize. Yes, the Assembly of First Nations is funded by the Canadian government, and they have like it's very hard for them to go against what Canada wants to try and implement because they get to be the bringers of also like it, almost like the bringers of assimilation also. So the difficulty is that when you're dealing with Indigenous nations, they are literally all different across Canada. And to sit there and think that you can have one group represent everyone, especially the Haudenosaunee people, it's very complex and very problematic in how to understand those issues. So those are like little things that you just want to kind of keep in the back of your head when you read a lot of these things where like take it at face value because that's what everyone's going to do, but at the same time there may be other issues that arise that may be a little bit more there for clarification that you might not have thought of.
And sorry, I just wanted to say this, Leslie, is that, even though we use the term Indigenous, there are many different First Nations across, North America, and we're not all the same. We're not, we don't speak the same language. We're all different. We all have our own cultural ways. So even though we used it as a generic term to cover part of the issues on here, each community does face their own problems. There's a lot of common problems that First Nations and Indigenous communities face together, but they do have their own individual issues at the same time. So we just used the generic term Indigenous for the podcast for today, but we didn't address any specific community really. Well, except for my sister who lives on Oneida, of course. And yeah. Sorry, and just I know you want to cut this that we've run a little long, but I do just want to add this one more thing, which is pretty shocking about the changes in the criminal code with respect to forced sterilization, and that was based on Indigenous women's continue being sterilized in this day and age, and so it's really sickening to know that. They did, like, the Canadian government actually did amend the criminal code to try and prevent that from happening, of Indigenous women being sterilized.
So it was happening. So Indigenous women are being sterilized against their will or without their consent, like recently enough that the Canadian government just passed a law saying you're not allowed to do that.
That's
I
right.
just want to
In
make sure I
November.
understand you correctly.
Yes. In November. They just passed it. They amended the criminal code in November of 2024. So yes, it is still going on.
So it's such a common practice that there had to be a specific law passed saying don't sterilize Native women without consent.
It does apply to every, like, for sterilization for everyone, but the basis.
Okay, well, as well it should. I mean, yes.
Yeah, but the reasons for the amendment was due to the forced sterilization of Indigenous women.
That is shocking. I thank you for sharing that. That I did not know that, Maureen.
So, yeah, and I thought it would be important because you wanted to know how the impact is still ongoing.
I do, yes. That's. I mean, I may not be the right way to phrase it, but that's exactly the sort of thing I want to know. As I say that, that it's horrific, but also thank you for sharing. There's a real conflict of emotions here.
Of course. I think it's information that a lot of people don't know, and that's just one example about why, like, what still is occurring, and yeah.
Well, Maureen, Bulbrook, and Christine, Ninham, thank you for taking the time out today, for speaking with me, for teaching me things that I didn't know and expanding my knowledge horizons. And I hope that you inspire our listeners as well to learn more about the current state of things here in Canada.
Thank you, Leslie.
Thank you very much, Leslie.
If you enjoyed today's podcast, please consider giving us a 5-star review and showing your support at patreon.com/podcastforinquiry. Email us podcast@centerforinquiry.ca. We'd love to hear your perspective. The Podcast for Inquiry is brought to you by the Centre for Inquiry Canada. We are a national educational charity supporting reason, compassion, and secular values. Help us support rational discourse and evidence-based decision-making by becoming a member at centerforinquiry.ca/join. CFIC is on the web, on Facebook, and you can follow us on Blue Sky at CFI Canada. Podcast for Inquiry is produced and edited by Zach Dumont and Martin Zielinski. Music by Anthony Lazaro. I'm your host, Leslie Rosenblatt. See you next time.